Okay, so it is 18:01. I'll take this opportunity to start the show. So welcome everybody, and thank you for joining us for today's webinar. My name is Danny Clark, and I am the founder of Simply People. Simply People are connecting a community to improve the physical and mental health and well-being of employees in the workplace. We're the fastest growing occupational health community in the UK, and we've helped organisations to find the right provider first time and offer a triage service to help them to do this. We also support providers with a range of support, skills development, and events like this. Today we're hosting Fit for Work and Occupational Health. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. I'll bring them up during the presentation, and we will also have time for questions at the end. There is also a chat box that you can use to communicate with us and the other participants. Our presenter today, trained as a barrister, cross-qualified as a solicitor. She is the founder and managing director of multi-award winning Thrive Law. She specialises in employment law throughout her career and has a keen interest in this subject. Without further ado, ladies and gents, let me introduce you to the wonderful, talented Miss Jodie Hill.
Hello, thank you. Thanks for the introduction, guys. So as Danny kindly said, I am the managing partner of Thrive Law. We specialise in employment law for businesses, but also for individuals, and we particularly work in areas around discrimination, diversity and inclusion. So it's a particular interest of mine, looking at disability discrimination and proactive measures to support individuals in the workplace, but also guiding employers through all the difficult bits that they often get confused with when it comes to the Equality Act and practical measures that they can put in place. So what I'm going to focus on today is, obviously I'm not an occupational health therapist or advisor. What I'm going to look at is the practicalities around when you're going to use occupational health, how to use them, reasonable adjustments and disability. So I'm going to link all of those things in, and hopefully you'll get some practical solutions out of this session today. Please do ask questions. The chat box is there. I will answer them at the end, but if you've got any burning questions, just start putting them in as you go through, and we'll pick those up at the end. So I'm going to turn my camera off whilst I go through the slides. And if you've got any questions, please just reach out and I'll pop it back on at the end. Okay, so just bear with me while I sort my tech. 1 second. There we go. Oh, that's just me. What the general position from an employment perspective is that an individual would be fit to work unless they tell you otherwise. Now, often an individual will present themselves either in the workplace with behavioural or physical symptoms where it looks as though they aren't fit for work, and in those situations you can approach an individual and ask them if they're struggling. Now, ordinarily, if an individual feels themselves that they're struggling, they can sign themselves off as you probably know, as a self-certified sick day for up to a period of 7 days. After that point, if they want to continue to be absent from work, they need to get a statement of fitness to work from their GP, and that will then identify what the reason is, what the illness is, and why they're off and for how long. So what's important for employers is that they must understand what the condition is for the individual. So often they may just say something like, oh, it might just say, I don't know, stress at work. And that for me is not enough information to really support an individual with their workplace or understanding when they'll come back to work. So it's a really, really important part of the process is when you know that there's a potential problem and someone may not be fit for work, to really understand why they might not be fit for work, and if there are any underlying conditions, long-term health conditions, or actually often what you can find is there's a combination of the two. So what I'd like to look at today is some of the things that employers can do. So bear with me. So first of all, looking proactively, there are loads of things that you can do from a well-being perspective, but actually the focus of today is really looking at when someone actually isn't fit for work, what do we do? So if they're unfit and they're off sick, one of the huge problems that we find in employment situations is the management of that sickness. So when they come back, or actually even if you're having some welfare meetings, and that's during the sick period, you must actively listen and not make assumptions. And what I mean by that is, often people will have a condition, and a manager may understand that condition because they've got a lived experience, or another employee's had it, and they can often make assumptions about what that employee may need, and that isn't the right approach. Whilst you might be trying to put that individual at ease, it actually can cause more problems if you just assume and already thinking of the answer before you actually listen to what the problem is. And I know that sounds really basic, but actually it's really, really important, a kind of starting point for organisations to really embed when they're looking at upskilling their managers around how to deal with these processes properly. So that creating that safe place and not making assumptions and actively listening creates an environment where individuals are likely to be more open about the type of support that they need. And actually, if it is a workplace issue that's causing the problem, then they're more likely to talk to you about that, and obviously explore things like adjustments, which I'll come on to. Where there is an actual sickness process in place, make sure you revert back to your company policy and process. It's really, really important. The amount of organisations who don't do that, and they forget that they've got timeframes or trigger points within their processes, and actually they either miss those or don't follow them, that can have an impact if you then go on to dismiss somebody. So obviously not thinking about dismissing people up from the outset, but if you follow the process all the way through, then if you do have to dismiss someone at the end for reasons of capability, then it's a much easier argument to have, because you've actually followed the process and you don't have to go back and do things again. And actually you can look at the fairness of the dismissal as well, because you've actually gone through the process you said you would go through. Keep paper trails. I always say this, obviously I'm a lawyer and always thinking about if it ends up in tribunal, but it's a really good way to think about these processes. And I know it can sound a little bit a bit miserable, kind of, oh, well, what happens in a tribunal? But essentially that's how I always think and advise my clients, because if you think in that way that a judge might read it, or a judge might want to see that document, it's a really helpful way in terms of managing what information you need when you're going through any internal process. And always think, if a judge was reading it, would they consider this to be objective, and is this something that they would expect to see as part of this process? So keeping paper trails could be of discussions that you've had with individuals, return to works, reviews, reasonable adjustments, what was agreed, all of that stuff is really, really important to keep a paper trail of. It can also be really helpful to keep the paper trails in, and when I say paper, it can be an email. Obviously, everyone's pretty much paper free at the moment, well, we certainly are. But it's just having a trail of documents that you can support why decisions have been made, what's been agreed, when it's been agreed, and when it's likely to be reviewed. So it is important to keep that, and actually making sure you keep that in a confidential space that other people can't access. I talked before about policies, but sick pay policies is a one that comes up an awful lot, because sometimes managers exercise discretion, say, oh, you can have this one paid, that's fine, but the contract or the policy says it's SSP. So just make sure that you're consistent across the board, because what can happen is if you don't apply it consistently and someone has a disability and you treat them less favourably and don't give them the extra pay, then it could be seen to be discriminatory. So there's a reason why the policies are there, and then that they should be applied consistently across the board. And obviously, if there are trigger points and thresholds that have been met, then you need to, first of all, proceed as normal. But then secondly, if you think they have a disability, is there an adjustment that you need to make to those processes? So again, policies and procedures often go, they're there, people don't read them often, but actually they can be really helpful when it comes to these types of situations, because not only does both the manager and the employee then know exactly where they stand, but also the timeframes are all set out there really clearly, and there's a step-by-step guide in most workplaces of how you will deal with the sickness absence monitoring policy or a capability process. So those are really, really helpful if you've got them in-house. If you haven't, you can look on the ACAS website for guidance around how to conduct those types of meetings. And finally, with managing sickness absence, one of the areas which obviously we're going to talk a lot about today is occupational health, but also the difference between getting that and medical evidence. Now, there's quite a lot of talk around this in the tribunals at the moment as to whether occupational health support amounts to medical evidence, and whether you need actual specific consultant reports for certain conditions. And to be honest, the answer is it depends, because it depends on what the condition is, what type of support you think as an organisation you need, and why you're getting that support. So I'll come on to it in a little bit more detail, but it is very fact specific in terms of what you would need, whether it's medical evidence. And when I say medical evidence, I mean, do we need to get a psychiatrist consultant to give a specific, some kind of report that's really specific to that condition, or do we need or do we want to get a report from the GP, or do we want an occupational health therapist to come in and actually advise on the role and adjustments? So it depends on what you need as to who you would use. But certainly, Simply People are really helpful in terms of that triage, where they can support. If you don't know what type of support you need, it's certainly something that you should look for, because even within occupational health support, what we find is that often people have different skill sets. So some occupational health support will be really bespoke to, say, I don't know, agricultural or manufacturing, and others really bespoke to mental health or physical health or sports. So it's finding people with the right skill sets within the professions as well is really important to try and help you get the best support possible, and obviously make sure the right adjustments are put in place. So I talked about disability before, and if anyone wants to know a little bit more about disability, you can have a look at we actually did a webinar on that a few weeks ago, I think, and then after that we did one on reasonable adjustments. So there's more in-depth information around disability and reasonable adjustments, but I am going to touch on it today because it is relevant for the purposes of kind of understanding when occupational health can be helpful in the workplace. So first of all, when we talk about disability, we need to think about this definition that I've put on the screen here. This is the definition that's set out in the Equality Act in Section 6. And the reason it's important is that if someone meets the definition where they have a physical or mental impairment that's had a substantial long-term adverse effect on their ability to do daily activities, then if they meet that definition, and I'll explain a little bit more about it in a second, then the employer has a duty to make reasonable adjustments. Okay, so that's why it's important, is that even if you don't necessarily know of all of the symptoms, you could still have some imputed knowledge in that you then have a duty that arises as a result. So the physical or mental impairment, that's relatively straightforward in terms of identifying if something is physical or mental. Substantial and adverse, we call it a negative or an adverse effect. The substantial element of it is looking at something that's more than minor or trivial, and that's often where you can get the support from occupational health or a medical practitioner to support you in understanding what the impact is of the condition on their ability to do day-to-day activities. So that's really what you're looking at, is how does this condition impact daily activities? Now, daily activities doesn't have to just be work related. It could be making their breakfast, boiling the kettle, washing, walking, getting the bus. So there's lots of different things that are encompassed within the definition, and it's not limited to working daily activities. It's normal day-to-day activities. And the final thing that's really important about the definition is how long someone has had this adverse impact. And it has to be at least 12 months, but if it hasn't been 12 months, but it's looking likely that it will be more than 12 months, then it may also meet the definition. So this is again where occupational health might be able to help. And what I've done further in the slides, I've actually put some questions up, some ideas of questions you can ask occupational health to really help you as an organisation understand what your duties are under the Equality Act. And it's actually questions that we use when we're drafting these for clients. So if someone has a disability, that's when the duty arises to make reasonable adjustments. Obviously, there are automatic disabilities, so cancer, HIV and MS. So what that means is they don't have to show what the impact is. It is just a disability under the Act. Any other condition has to meet the definition. And Obviously, some conditions, like say, for example, anxiety, in one person may be a disability and another person not. So you can't take a blanket approach to a condition is a disability, save for the automatic ones. You do have to look at it in a slightly different perspective for every single individual, and it's a case by case factual basis. Knowledge is really important. So where I've put there, the does the employer know, it's really important to understand why that's there, because effectively, if you have a record anywhere, so say if the statement of fitness to work or a return to work interview or an email someone telling you about a condition, that could be seen as knowledge. So even if the entire organization doesn't know, if someone in the company knows of a condition that could meet that definition, then that's when the duty arises. So it's really important that your internal processes, when it comes to anyone mentioning anything about a potential disability or a condition that might need support, is registered somewhere centrally, so that people are aware in the organization. Now, obviously, when I say centrally, I don't mean so that the entire workforce knows, but it's more from a management perspective, so that if any adjustments are needed, there is a central record and they're aware of it. So if you've got any questions on disability, obviously I can answer those at the end. And then obviously I talked about reasonable adjustments. Now, the whole purpose of the reasonable adjustments is to really put the disabled person back in the position they would have been if they didn't have a disability in the workplace. So obviously most of the time it's not able, the adjustments don't completely remove the disadvantage, but what they do is they minimize the disadvantage that they've faced in the workplace. So the idea is that it substantially reduces the impact rather than fully removing it. Obviously, in certain situations, say for example, with a physical condition, if access is difficult because they're in a wheelchair, then putting a ramp in will remove the disadvantage. That's fine, but often it's a bit more nuanced than that, and actually you're looking at how you can minimise the disadvantage faced by an individual who has a disability. So the idea behind the adjustments is that, first of all, from an employer's perspective, they agree it with the individual, and that individual believes that it will allow them to function in their role as though they either didn't have the disability or removing the disadvantage to a certain degree. Now, it's very difficult because often employers will want the individual to tell them what they need to do, and the individual doesn't really know what they will need, and the employer doesn't know what they'll need. And I suppose that's where, in my view, occupational health would come in. There are certain disabilities that it's difficult when there's someone who's got lots of short-term sickness absences, and they may be a disability, they may not be a disability. Again, just go back to the definition. If it's a fluctuating condition, and it's actually the same condition but they fluctuate in and out, so that often with mental health conditions that can be the case, and it could meet the definition. So just because it's not consistently for 12 months doesn't mean it won't meet the definition. So again, if there are repeated short-term sicknesses but of the same sickness, then it could still meet the definition. But if they're not linked and it's not the same condition, then actually it's unlikely to meet the definition, because actually it's a series of different conditions. I don't know, it might be like flu, a cold, a bug, that type of thing. That's really unlikely that any of those, unless they're caused by a disability, would meet the definition. So if you do have any issues with, and one of the big questions we often get is, someone's always pulling a sickie, they've always got something else wrong, they always have a bug on a Monday, they always have an issue on a Friday afternoon. So those types of patterns, have a look for those. And also have a think about the policies that you've got in place. Do you have any trigger points for short-term sickness absence? I think it's really helpful to have a really clear communication around that, because if you don't, and say for example someone just has one day off every Friday or every Monday, and there's no trigger points, it can make it a little bit more difficult to, because they can self-certify obviously for those periods of time, can make it more difficult to manage. So it's certainly something to think about from a policy perspective and a training perspective, if you haven't already thought of that. And then finally, when it comes to, when it comes to to sickness and being fit to work, where someone looks like they're actually abusing the process or they have been dishonest about sickness, you can actually, rather than going down the capability route, you can go down the disciplinary route for dealing with that, because it's actually seen as misconduct rather than capability, because they're abusing the system, they're actually being dishonest. It's a really fine line, actually, to establish that. I've had to deal with it a few times, and the individuals have been caught out because they've been, I don't know, posting on social media, said they were ill and were at a party on social media, or have told someone else in the workplace, oh, I'm going to pull a sickie, that type of thing. You can still deal with as a disciplinary action. Okay, let's go on to the role of occupational health. So occupational health are really there to support employers, in my view, to help them understand whether individuals are fit to work and in what capacity. So often the reason why they're recommended, or sorry, should I say referred to occupational health, is that an individual is either already disclosed a condition, or the employer feels as though they may need some support in their role. So it generally comes up in my experience where an employer has either brought someone back to work off long-term sick, or they're struggling currently in their role. They don't have to be on long-term sick. And the idea behind occupational health is really to help the employer and the employee come to an arrangement around what kind of reasonable adjustments or support they might need in their role. And they don't have to have a disability for this to happen. Now, obviously, the duty arises to make reasonable adjustments where someone has a disability, but you don't need to have someone who meets the definition to make the adjustment. So hopefully that makes sense. The obligation is there for those people who have a disability, but actually making reasonable adjustments for anyone who needs it in the workplace, to me, is common sense. If someone's struggling or someone needs support but they don't meet the definition, say because they've only had their condition for 8 months, then I would still make whether or not you think they're disabled, I'd still make the reasonable adjustments. And occupational health can help understand what adjustments would be reasonable, and also what adjustments would alleviate any disadvantage that they're facing in the workplace. They can also help you understand whether or not the person has a disability. So again, often workplaces will want to know whether it meets the definition, and part of that is actually understanding, well, what is the impact? So when I talked about the definition before, that's a legal definition. It's not a medical definition. So just be really careful when you are advised from someone who is a medical practitioner or an occupational health advisor that someone meets the definition of disability. It doesn't always mean that they are disabled, and you don't have to follow the advice. Obviously, it's there as guidance and recommendations, but it is a legal question. So they can really help you understand the impact. And that's what I find occupational health are really, really good for, because they understand the impact of the condition on the person in their role. So they can talk about it from that perspective, and they can certainly help you understand whether or not the employee meets the definition. But it's, as a word of caution, there's been some case law recently where people relied really heavily on what occupational health said, and the tribunal disagreed with that. And they said that they should have looked internally, as well as used it as guidance, but actually assessed that internally and spoken to the individual as well. So like I say, it is really, really helpful to have occupational health support for these different areas, but it's still your responsibility as an employer to make the decision and make an objective decision based on all of the information that you've got, including the occupational health reports. So just got an example of how occupational health might assist, and I'm sure that most of you will have used occupational health before, but here we are. Got an example. So and I always use a physical injury because I think it's an easier analogy for people to understand than a mental health one. But I've got loads of mental health ones because that's something that I specialise in. So at the end, if anyone wants to ask any questions about reasonable adjustments or types of support for people with mental health conditions, then we can talk about that. But here we've got an example of an employee who has a back injury. The employer asks occupational health advisor to carry out an assessment for them, and the result of that is that the assessment identifies the type of support they need in terms of physical adjustments to their chair. The employer then arranges the adjustment off the back of that, and that is then something that the employee has in the workplace on a permanent basis to alleviate the disadvantage faced. So the disadvantage faced by this person was the pain and discomfort during the working day while sat at their desk. So you can kind of see how the process works and the benefit to having them there. Now, in this particular example, they will also be able to, some, not everybody, but some advisors will also be able to identify what type of chair or what type of back support as well. So you can go a little bit further than simply just asking what it is, what type of adjustment. They can actually help you to source those if it's a physical thing as well. Okay, so I talked briefly before about when to refer to occupational health. Well, where there's a dispute internally, so whether that's the individual or the managers can't decide what's reasonable, or whether or not someone's fit to work, or whether or not there are any adjustments to be made to the role, or if, for example, where the employee can't think of anything and neither can the employer, having that external and objective approach from someone who's an expert, that is when they can be adding so much more value than simply you guys trying to work out what a reasonable adjustment would be or whether someone is fit. Obviously, you can also speak to the GP, but actually I feel like letters from the GP are really unhelpful. Sorry if there's any GPs on the line. It's just in my experience that occupational health tends to be a little bit more focused in the workplace. They can help you establish reasonable adjustments, and they can also help you doing those reviews as well of the reasonable adjustments, because sometimes adjustments are only needed for a temporary basis. So again, if someone's got a review coming up and they might not need, it often comes up with mental health or phased return to work, that type of thing, they can support with that as well, rather than just doing it as a one-off. They can be part of the process long term. They can also help with ill health retirement and health and safety obligations as well. So there's all sorts of areas that can help with, not just looking at disability and reasonable adjustments. I talked before about Simply People and how they have the triage service. I know people that have used it and have found that picking the right specialist is really, really important, making sure they have the specialism to support the individual and their particular condition. One of the things I think is really important is that the employer gives clear instructions and a clear brief of exactly what they need them to do. So I said before about the fact I've got a couple of questions on here, and you guys can have the slides, but be really specific in the types of questions that you're asking them. Don't be vague. If you're vague, you'll probably get a vague or an unhelpful response, and you can't blame the occupational health advisor for that if you haven't been clear. And often then, you've got the report and there may be an additional cost to amend it. I don't know how the cost thing works, and obviously that's dependent on advisor, but it's just something to be mindful of, especially if you're paying independently for that. So with occupational health advisors, they will have obviously their own confidentiality obligations to their patients. So there's an element of, you can ask them questions and you're instructing them as an organisation, but they will be able to consult with the employee, and the employee can have a look at that report first. So just be mindful that they will have obligations to their patients, as well as the fact that you're instructing them. So it's a two-way thing for them. Okay, so I'm going to go through a couple of questions, and hopefully I'm just going to run through them relatively quickly, because like I said, you can have a copy of the slides, but you want to be asking questions around whether the individual's fit to work. If not, then when will they be fit to work and for how long, and will they need any adjustments? Will a phased return be appropriate? If they need adjustments, how long are those adjustments needed? What are they? How will they alleviate the disadvantage? So really asking quite a lot of in-depth questions so that you can find out as much detail as possible how this will help the individual in their role, rather than just saying, is this person disabled? What adjustments do they need? I think you need to go into so much more detail than that to really understand how this will help the individual. And then I suppose from a business perspective, if there's a big cost, but you know that it will remove the disadvantage or it will significantly improve their work life experience, then actually you can objectively justify it more if you know that the impact is going to be profound. Whereas if if it's just a range of adjustments that have been suggested, but some of them actually don't alleviate the disadvantage an awful lot, then that again will help the business to understand whether it's a reasonable adjustment and whether you can justify any proportionate costs that are associated with it. I talked before about the definition, and I think you can ask questions around the definition, but I'd go a bit deeper than just saying, do you think they're disabled? I would go into the definition that I put on the previous slides and actually ask them, is it a physical or mental impairment? Do you think it has a substantial and adverse long-term effect on their ability to carry out daily activities? If so, what is the substantial effect? And how is it long term? How long have they suffered? How long are they likely to suffer? So that the business has a better understanding of how long this is likely to last and whether or not they actually meet the definition. The other thing that's quite helpful to understand is where an employee is already receiving any medical support. So that could be through physio or therapy or medication. So understanding what current support they already have. It's helpful just for the employer to know anyway, but actually from a disability perspective, if someone is on medication, then when we're looking at the definition, you actually look at what their life would be without the medication. So whether that's for mental impairments or for pain relief or whatever it might be, you actually look at the condition without the support when you're looking at the substantial disadvantage. So again, that can be really helpful when questioning around whether it's actually a disability. Obviously, if you are going to ask for advice on reasonable adjustments, looking at what their actual job is really important. So if you just ask what adjustments could be made and the occupational therapist doesn't know what they're required to do in their role, again, that can be really unhelpful, because ultimately they need to know exactly, and obviously they can ask the individual, but I do think it's helpful from an employer's perspective to send over a job description, because they can then identify if there's any particular areas of their role that they can't do and any that they can, but only with restrictions. Another thing that's really helpful to understand is where the illness could be caused or exacerbated by work. Whilst often, employers don't want to know that because they don't think their workplace is stressful, it can be stressful for people, or it could be exacerbated by their chair or their workplace or whatever it is. It's better to know about it now, and if it is exacerbated by that, is that something you can adjust? So it's about being proactive and not defensive when you get the report back on those areas. And finally, the something that comes up quite a lot, especially when someone is driving a machine or working in a factory where medication might impair their ability to do their job. So again, it's really important to understand that if they are taking medication, what impact does that have on their ability to just do their role? So there's lots of other questions, and I will, if anyone wants, in fact, there's a slide later on, if anyone does want a free template of a letter of instruction that they can use for instructing occupational health, I'm going to offer everybody a free template for that if you just email me, but I'll pop that on one of the slides later. But I thought it's just worth explaining now, so you don't scribble everything down. I can send you the slides and I can send you a template so that you've got something to work on. Obviously, every single instruction is going to be completely fact specific, but you'll have some basic questions that you will want to cover and some basic topics that you'll want to make sure are included so that you get the information that you need. So with occupational health referrals or any medical referrals, you do need employee consent. What I always recommend is that you explain why the referral is happening. What we find is often people can become really defensive if they don't know, and they just get a letter that says you've been asked to speak to, I don't know, somebody, and they don't know who that is, and they feel a little bit put out by the fact that there's been no communication around it. So even if it is something that is in your contract or in your policies or that is widely used, for every individual that is referred, I think you need to sit down and explain to them why it's happening. The communication piece around that will help them to engage in the process as much as possible, especially if the organisation is having to pay for it. Then clearly you want the employee to engage as much as possible, and obviously if you can get their consent to proceed, that's really, really helpful, because it means that you can streamline that process and get the information you need to put the adjustments in place. But so many employees actually refuse to give consent, and it's quite common. I don't know why a lot of the time, but I suppose it's a trust thing. But essentially, getting that consent, you can obviously ask them for the consent. It may be in their contract already that they would consent to it. But like I say, if you set the scene and you explain why the referral is taking place and how it will help them in their role, then ordinarily I find that people are quite willing to engage in it. One thing often employees are worried about with occupational health is that the occupational health advisor will tell the employer everything. So again, just the communication piece around how it works and the fact that they can see the report before it goes to the employer and make sure it's correct, that type of thing. So that communication piece, like I say, is really, really helpful. As I've said before, the employee can attend occupational health but then refuse access to the medical records. So they've got the fact that they might refuse consent altogether. They could refuse consent of the report being sent to the employer, and they could also refuse consent for access to medical records. But if that happens, essentially all you have to do is explain to the employee what the net result of that is, and it is that you as an organisation can only make a decision based on the information before you. So it's in their interests to allow the occupational health or to access the medical records and to allow the employer to see that report. If they refuse that and they're aware of the risk, then you can make a decision about what to do without that report if it comes to that. And that's fair and reasonable, provided you've communicated it to them. So obviously we want to avoid that, but essentially these things do happen, and that's often where employers do get stuck because they don't really know what to do moving forward. Oh, look, I've jumped ahead. So employees, like I said, communication is key. If there's anything in the contract, then try to refer to that when you're explaining it to them if they are refusing. Now, in the contracts we draft, we always have a clause that says you'll consent to any reasonable medical report and occupational health referral. So again, if you haven't got something like that in, it might be helpful just to push people in the right direction, and also to manage expectations. They know from day one that that's a possibility if it becomes necessary. And then if worst case scenario, they consistently refuse and they're being really difficult about it, you can argue that it's a failure to follow a reasonable management instruction. But I do think it's a bit risky to go down that route, because if the individual has a disability, they could say, oh, well, if I didn't have a disability, I wouldn't have been referred to occupational health, and therefore the fact that you're disciplining me for misconduct arises out of that disability. So could be a Section 15 disability discrimination claim. So I do think it's a bit risky, and I would avoid going down that route. Try and keep it as conciliatory as possible, because that's the whole point of engaging with specialists, is that actually you're doing that to help the individual and to understand how you can support them in the workplace. I've already mentioned actually that the employee can see the report first, but they still have to consent for it to be sent to the employer. If they refuse consent, as I said before, you just need to remind them that if they refuse that, you can make a decision about, and it could be part of a capability process, it could be part of a reasonable adjustments or a return to work, whatever it is. Just explain to them that a decision will be made based on the evidence before them, and if they're not consenting to the report being released, then that won't be part of the evidence that they can consider. Once the report has been received, once it's been consented to and it's been released and sent to the employer, the manager should review all of that and actually consider what adjustments that they think are reasonable to put in place, and then discuss that with the employee. You don't have to put all of the adjustments that are recommended by occupational health in place, because it's about assessing what's reasonable for your business. So the reasonableness of that isn't always encompassed within the OH report, because they may not know the administrative and size of the administrative resources and the size of your organisation, or whether or not it is something that could actually be implemented. So they'll make a load of suggestions, and then it's for you to work out with the employee which ones are reasonable and which ones you're going to put in place. So as I said before, they are guidelines. If you don't want to follow the guidelines because either you think that the recommendations or the reasonable adjustments suggested don't make or don't amount to reasonable adjustments, then that's fine, but you need to make sure that you keep a note of the reasons why, and so that you can objectively justify it if they challenge it. And I would also, if you are going to use occupational health and then not use any of the recommendations or guidance, you need to have a good and strong conversation with the individual to explain why you haven't done that and what you're going to do instead. So where an employee is incapable of doing their job, there is obviously the capability process that you can go through. Now, occupational health can often be brought in before that from a reasonable adjustments perspective, or as part of a capability dismissal process. So they can literally be brought in at any stage of employment. There isn't a set criteria of when you should or shouldn't bring them in, but essentially these are the areas that they tend to be involved in more so with HR and with management. So where someone's incapable of doing their job, often that what can be really beneficial from occupational health is that where they can talk about the recovery time, what realistically how if someone's been off sick and they're incapable of doing it. I'm not meaning capabilities in performance, sorry, there's two different types of capability. So if someone needs some time to recover, but then they'll be fine at it, so for example they can look at a prognosis date when they would actually be able to return. Now, if it looks as though that individual probably isn't going to be okay for like 12 months or longer, then again, that can be really helpful in justifying why you may have to dismiss them for capability reasons. And it's not because they're not performing, it's because they're physically incapable of coming back to their job at any time soon. So again, those reports can be really helpful in determining whether or not it's a fair reason to dismiss for capability. If you follow your process, then they should absolutely be fine. But you do have to bear in mind that people with under 2 years employment may still have a disability, so it could still be linked to a disability. So even where we talk about unfair dismissal and the fact you have to have 2 years employment in order to be covered, for capability dismissals the same applies. But when you have a capability dismissal, that person may also have a disability, so I'd still follow the procedure even if they don't have 2 years employment, mainly because what you want to establish is that you've explored everything before dismissing them. And actually, if you've already gone through occupational health and looked at adjustments and that's the final hurdle, then that's fine. But what we often find is that doesn't happen, and because they don't follow the procedure, because they've got under 2 years employment and then they dismiss the individual because of long-term sickness absence, that sickness absence arose as a consequence of disability potentially, and actually there's quite a lot of case law to say that if the employer had done the process properly and got the correct medical evidence and done a proper investigation, they would have known that they'd had a disability and they shouldn't have dismissed. So again, you've got all these complications that come into play, which again is why it's so important to engage people like occupational health early doors, because you can actually say that we've already taken advice on an objective view, this person is not going to be returning within the next 12 months. And then you can objectively justify it. So obviously I talk a lot about claims, but it's because I'm acutely aware of the risks, and I'm in tribunal an awful lot defending and bringing claims. I work with employers and employees, so I see it from both sides of how it goes wrong, or actually how it can be done better, and obviously what the main crux of the claims are, where people get it wrong. So hopefully this is helpful, talking around some of the risks. I'm not trying to scare people. It's just the way that the way that I pick those things up is because I actually see it in tribunal and how the judges approach it, and I think that can often be really helpful to see how that would then transpire into HR and actually running a business and managing some of these really difficult processes. So yeah, there we go, the risks. So I talked about disability discrimination claims. If we get it wrong, there's a few different types of disability discrimination claims. There's claims around failure to make reasonable adjustments. There's the Section 15 claims. I did do a couple of webinars on disability discrimination and on reasonable adjustments. There's loads of stuff that I did with Simply People if you want to know more about those types of claims. If it could be unfair dismissal if you dismiss them and you haven't explored things like adjustments, or if they resign because you've refused to make an adjustment and they say that that's an act of discrimination, then it could be constructive unfair dismissal. Obviously, those two claims only apply where someone has more than 2 years service. Disability discrimination claims can arise from day one, and in fact in the application process as well. The employees do have only 3 months less 1 day to bring a claim. So what they have to do is approach ACAS first. So if you are worried about anything when someone has either been dismissed or has left and is threatening to bring a claim, you will know before they issue a claim, because they have to go to ACAS. And at that point, you can then assess what the risks are and assess whether it is something actually you made a mistake and perhaps it is a discrimination claim, so it needs to be settled. Or if it's not, you can then look at whether you want to defend it. So that's almost me done. I said at well, partway through that we're offering some free templates. I'm really keen to support people with this type of thing, because getting it right can have a huge benefit, not only to the organisation but to the individual who has a potential disability. So getting it right is really important. So if you do want a free template, just drop me an email. My email address is on the slide now. And then just a little bit about how we might be able to help you guys. We offer all sorts of different advice for individuals and companies, but predominantly looking to work with people around HR support. So one of the things we do is, obviously our advice is privileged compared to a HR advisor. So anything you say to us about a disability or a particular process can't be used in evidence, whereas it can if it's a HR person. So we're really keen to support businesses so they can have those open and more difficult conversations with us. And we offer loads of free stuff around like bulletins and coronavirus updates and all of that stuff as well. So if anyone wants me to pop them on my database for any of the free updates or access to events, then just let me know by emailing me. And then there's just a bit of information about Thrive Wellbeing, but I'm conscious that there'll probably be questions, so I'm going to take some questions. But essentially, Thrive Wellbeing is around supporting individuals and businesses with their wellbeing in the workplace. So we have all sorts of stuff you can see on the slide there, from training to guides to toolkits to emails and policies and all sorts of stuff within the platform. It's a tech platform, and it's really cost effective. It's like £2 a month per employee or something, maximum price. So if anyone wants free access to that, to have a little look around and see if it might help them with their well-being, then happy to arrange free access to anyone that's on the call. And then finally, if you're interested in any of the areas that we've talked about, I've got loads of stuff on YouTube in more bite-sized chunks. So there's a link to that in the slides if anyone wants any further kind of guidance on any of those topics. Loads of stuff around all different areas as well, not just disability. And we do have some free advice lines. So if anyone has any questions afterwards that's coronavirus related, or we actually have a BLM support line. If it's neither of those related and it's something about what we've talked about today, but you don't want to ask a question, you can just email me, which was this one here, and I'll be happy to answer any questions confidentially if you don't want to ask them publicly. And I think that's me done. So have we got any questions?
We do indeed. Thank you very much. Thanks, Jodie. So yes, we've got a number of questions. Let's start with the first one. So the first question from Paul says, what happens when the employer instructs the employee that they're not fit for work? Then instructs the employee to get a sick note from their GP, and also instructs the employee what to get the GP to write in the sick note. Huh?
So I don't understand what the question is. Say that again.
Yeah, so the question says, what happens when the employer instructs the employee that they are not fit for work? Then instructs the employee to get a sick note from their GP.
Mm-hmm.
So I'm guessing it's the employer that's decided the employee is not fit for work.
Okay,
but then ask them to. So yeah, so that's my interpretation of it. If I've not got that right, Paul, please drop a line, or ask the question again. But for me, I'm guessing it's the employer that's made the conclusion that they're not fit for work, and but then as part of their process, they then require the employee to get a sick note.
Yeah, I mean, ultimately, if an employee isn't fit for work, you would want them to go and see their GP, and that would be the first point of call. I mean, you can get occupational health involved, but if you think they're not fit for work that day, I would be sending them home and asking them to see their doctor, and then getting occupational health involved when they return to work in terms of looking at how they can support them when they come back.
I think that's it. Yeah, I think it's just normal process, isn't it? Next question is, what happens if the employer refuses reasonable adjustments?
So if the employer refuses a reasonable adjustment, I suppose the first thing is why have they refused it, and was it reasonable in the first place? If the employee thinks that it was reasonable and the employer has unreasonably refused it, then the employer could be potentially liable for a claim for failure to make reasonable adjustments under Section 20 of the Equality Act. So it's very fact specific. So it's very difficult to say, well, what if they refuse? Because it depends why they've refused and whether the person has a disability. And secondly, whether or not it actually was reasonable in the first place. So there's quite a lot to consider, but essentially, if they refuse outright and just don't consider it, then they could be liable under the Equality Act for a claim. And effectively, the claims under the Equality Act, you are able to claim injury to feelings. It's quite a difficult one to quantify, but it's usually around like £5,000 to £10,000 for something like disability discrimination.
Okay, thank you very much. I hope that's answered your question again, Paul. Next question, would it not be better for occupational health to decide whether a specialist report is needed in order to advise the client, as OH can interpret the information and make it relevant to the workplace?
Yeah, so that can happen, and certainly you'll find that there are situations where that is appropriate. So when I said before about looking at whether or not a specialist is preferred, now it's very fact specific, so it really depends on the condition, the workplace, that kind of thing. But yeah, essentially, occupational health can work with other specialists, especially where someone already is being treated by someone, and they can help interpret that from a workplace perspective for sure.
Awesome. Next question, if an employee decided, if an employee declared that an occupational health practitioner, they were suffering with a condition or work-related stress that was causing symptoms, but they did not give consent for that to be shared to their employer, would the employer be deemed as knowing?
Okay, so let's work that back. So the employer know, but they just didn't give
So,
consent.
so the employee has gone to
Yeah.
the occupational health, declared a medical condition to occupational health, but they then asked that condition is not declared or released to the employer. Because the employer's arranged the OH appointment, would they be deemed as knowing?
No, so they wouldn't know unless they actually know, because the Oc Health isn't part of the internal company. Usually, they're usually an outsourced individual. So it's only where they've actually seen the reports. If they don't consent to it and they've never seen the report, they wouldn't have any knowledge of the impact necessarily. They may have knowledge because not necessarily because they've not seen the report, obviously, but they may have knowledge because they know of the impact it's had on the individual, and that's why they referred them. So they could have knowledge in a different way, but they certainly wouldn't have knowledge from a report they hadn't seen. One of the ways that knowledge is actually assessed is whether it was reasonable or the employer ought to have known. So sometimes the employee doesn't even have to tell them. It's just obvious from the way that they're behaving in the workplace or how they appear. So again, it's not as you don't need a report or a diagnosis to confirm knowledge.
Well, that brings us into the next question, which is, if the person hasn't made you aware of it, but they have a relative working at the same company and they've mentioned it, would that count?
Potentially, depends what they've mentioned. So when we're talking about knowledge, it's not just knowledge that they have a condition. It's got to be knowledge of the condition and the impact it has on their ability to do daily activities. So just by saying someone has anxiety doesn't necessarily mean the employer know of the impact, because you can have anxiety and it's not a disability. So it depends on what they've been told effectively, rather than just knowing of a condition, if that makes sense.
Yeah, I think so. What happens if the employer then refuses to acknowledge the original instruction given to the employee when on long-term sickness, even when the employee has instruction from the employer in writing?
What do they mean by the instruction?
I'm not quite sure of this question. I'm literally just reading through the question. I'm trying to work it out. So what happens if an employer refuses to acknowledge the original instructions given to the employee when on long-term sick, even when the employee has instruction from the employer in writing? So it looks like the employer has given an employee an instruction in writing that the employer then refuses to acknowledge when they come back.
It sounds as though
quite a specific case.
Yeah, it also sounds as though that's a specific instruction. Sounds like that might be a reasonable adjustment. So if that's what you're meaning, if they're refusing to do that and they've agreed to do it, again, it's looking at whether or not that's a failure to make reasonable adjustments. And if it is, obviously looking at, is it a disability? Was it reasonable? Why did they refuse? To see whether or not, because just because something's been agreed doesn't automatically mean there's a claim. It's about understanding, well, why has it not happened. The other thing that can really impact on, if obviously if employers behave in that way, is that it can damage the mutual trust and confidence. And obviously if someone's off with a mental health problem, it can also exacerbate their condition. So just be really mindful that if you agree to do something, then you follow that through. By refusing to do it at a later date, even though you've agreed it in writing, can really damage the relationship.
Thank you very much. Here's an interesting one. Can an employee request that a particular person, i.e. their line manager, does not see the Occ Health report?
They can.
I'm guessing it means they can release it to the employer generally, as in I'll release it to HR, but I don't want my line manager to see it.
So they can do that. I suppose it's their personal data, isn't it? So they can obviously say who they want to see it. But I do think practically that can be really difficult to manage, because often the manager will need to know about the condition to be able to manage them. So depending on why they say that, I think if that was me being asked that question, I'd want to know, well, why don't you want them to see it? And if it's because their manager's the cause of the problem, then actually it's not that the manager can't see it, it's that you probably need to change the manager. So it's actually I think for me, it's not as a simple yes or no. It's about understanding, well, why don't they want them to see it, and why, what adjustments they need putting in place. Because if it's the manager that has to implement the adjustments, then that makes it impossible to affect it. So hopefully that answers the question.
Yeah, I think so. Here's one relevant to COVID. So if someone is on sick leave for several months while they're being investigated, and obviously at the moment lots of procedures and investigations are being delayed due to current circumstances, how often should there be a meeting or communication between the employee and manager? What would be reasonable as a guideline?
Well, it's actually quite a difficult one, because what's reasonable to one employer is different to another. First thing I do is check the policy around whether or not they have a specified time frame in terms of what would be reasonable. If they don't, I would always agree that with the individual, because again, if it depends on their condition, but some people don't want to be contacted loads. Other people want to be send a text message, and other people might want a call or a welfare face-to-face visit. So really depends on the individual. So if you're not sure, if the question is more because you have a specific scenario and someone's waited way too long and you think it's too long, then email me and I can tell you whether or not I think it's unreasonable or not. But essentially what's reasonable to one person is going to be not reasonable to another, and again it depends on the personal circumstances. So it's a bit of a difficult one. Reasonableness is a really difficult one to define because it's so subjective.
Absolutely. Should you exhaust company sick pay before considering dismissal?
You don't have to. Again, you can check what your internal processes say on that, and whether or not that's a trigger point. However, when looking at the reasonableness of the dismissal, there would potentially be an argument to say, well, dismissal was inevitable, but it was done too early. So they could potentially win a claim, depending on what other options were available. But yeah, I mean, there's no legal requirement for you to do that. But when you're looking at the reasonableness of any dismissal, that could be something that could be taken into consideration in terms of what you could have done to avoid it.
Perfect. The rest seem to be comments or questions relating to specifics. So what I'll do, Jodie, is I'll share those specifics with you, and you can go back to those people rather than share it in a public forum. If there's no more questions, there's one just come in. Sorry. Are there any recommendations about timelines for implementing reasonable adjustments?
Yeah, so in terms of, I actually always ask the, as part of the questions to occupational health, that's one of the things that you would ask. I mean, if you can identify a reasonable adjustment, I would try and implement it immediately as soon as you have the report and work with the individual. Obviously, if you have to buy something or you need a physical piece of equipment, then it's just managing expectations, working out how long that will take to actually implement. If it's physically building something, obviously it's a bit different to just changing someone's hours. So depends on the adjustment, but actually just make sure that communication is really clear with the individual so that they know when it will take place, and if there is a delay, why that delay is taking place, and when it's actually likely to be put in place.
Amazing. Thank you so much. I think that's the last question. Thank you everybody. Thank you for attending today. Thank you for enjoying the session as much as you always do, no doubt. We are looking to run some more sessions, or we have got more sessions on the website, and moving forwards we will be running more of these occupational health and employment law sessions for everybody to hopefully learn and engage and develop. Thanks so much for attending tonight. That is the end of the presentation. The slides will be sent out after the session, so if you do like a copy of those, please do let me know. Thanks for coming.
Thank you. Thanks a lot, guys. And like I say, if you've got any questions that you want to email me direct, then you can do.
Thanks, everybody.